Yes.
Well, the issue is very short. That section 9B, which was inserted in Assam Agriculture Income Tax, 8B, which was inserted in the Assam Agriculture Income Tax Act by the Amendment Act of 2009, and which came into force from 1st April 2009, whether same can be applied for the year 2008-9, income of the year 2008-9. The submission which was advanced for the before the single judge group, that the division bench, while considering the matter, had not considered, in fact, the matter judgments were not placed before the division bench, that the law which will be the tax rate which will be applicable is in respect of the first day of the assessment year. You'll also kindly take the example. In case this is applicable in respect of the year 2008-9, then in any case, whenever the rates are changed, like in the union budget, the budget is announced and the finance act comes and the rates are changed, they are applicable for the financial year which is going on. It cannot be applied for the period which has already expired. Now, if
Even for the assessment.
my lord, my submission was that it has to be applied for the financial year 2009-10, relevant to the assessment year 10-11. If it is applied for the financial year 2008-9, then the same has already expired. Period has already expired. And in respect of that, if it is made applicable, then it will amount to a retrospective levy of the tax for the year which has already passed.
So the division bench has held that it will apply for 2008-9. Assessment year of 2009-10 will relate to the financial year of 2008-10. Correct. Now, what does the Supreme Court say?
Supreme Court said not that it will be applicable on the first day of the assessment year.
But that was different. But that was the assessment year. There was effective from September.
Hello?
Yeah. The assessment year with regard to the Supreme Court case was that it would be effective from September.
No, that was the assessment year earlier, what happened. The years, previous years were different. Earlier, the financial year was not the previous year. Diwali year, Ramnami, all those periods were different in the earlier period. But the law which was constitution bench, we decided. Okay.
Are in thorough tea estate.
My lord. Tea state. You'll also kindly see, my lord.
Yeah.
At page 264. I think the fourth paragraph now. Have you lost it?
Yes, now.
Now it is well settled that Income Tax Act, as it stands amended on the first day of April of any financial year, must apply to the assessments of that year. Any amendment in the Act which come into force after the first day of April of the financial year would not apply to the assessment for that year, even if the assessment is actually made after the amendments come into force. So in our case, it is 1st April. Now, 1st April of the financial year, that means 2009-10, it will apply for the assessment year in respect of the financial year 2009-10. Now, the
year is of 2009-10. But the financial year will be of 2008.
Well, in respect of the assessment year 2009-10, the financial year will be 2008-9. But this has been amended on the 1st April 2009.
Correct.
So, 1st April 2009 of the financial year, that means it will apply to the assessment year in respect of the financial year 2009-10. I will also kindly note it.
No, let us see the amendments.
What does it? You will also see page 23.
Yes.
at page 24, Milo. 3, Milo. It shall come into force on first day of April 2009.
See, there's no big
24, 24, Milo.
There is two, one, three. Yes, it can come into force.
Milo, 2,
Because there-
3, you will also see. 1, 3. It shall come into force on the first day of April 2009.
there-
Now, any amendment, Milo, it is in respect of the previous accounting year, Milo. It is not with respect to the assessment year. The law which stands on the first day of on the 1st of April of the assessment year will be applicable in respect of the financial year. But the amendments are made in respect of the accounting year, financial year. As, for example, I am giving you the current budget which has been announced, the rates, income tax act, whatever has been changed. Now, it will not apply in respect of the last year. It will apply for the accounting year, the current year, 2026-27, relevant to the assessment year 27-28. Now, lost in further note, Milord.
let us see 8B. What does it say?
Well, I will place Milord here one point I will place, Milord. The rules which were framed to give effect to this provision were framed in July 2010 because they were aware that this is not applicable for the assessment year, financial year 2008-9. Otherwise, Milord, you're asking me just imagine, Milord, if it would have been applicable for the financial year 2008-9, then the advance tax has to be paid, the returns will have to be submitted, the tax has to be paid, the interest has to be paid. Even the rules were not framed. The rules were framed in 2010, July 2010. Now, how a person in respect of the income of 2008-9 can submit the returns, can pay the advance tax in 2009-10, and he is liable to pay the interest also. When the rate was not there, tax was not there, then for respect of 8-9, how he can do it and how he will submit the returns? The returns were forms, etc. were prescribed in 2010, July. You'll also just see, Milo.
No, those aren't the merits. The basic issue, I think, is whether there is any difference in the judgment of the division bench of this court and the Supreme Court judgment.
Well, you'll also just 3 lines if you'll also take of the division bench judgment, Milo. At page 51, paragraph 5, Milo. We are unable to accept this submission under the scheme of the Act. The tax is payable for the agriculture income of the previous year. The assessment is made in the next year, that is, in the assessment year as applicable rate of tax. Admittedly, the amendment provisions are applicable for the assessment year in question, and the same could be applied for the previous year, irrespective of the fact that in the previous year the same provision was not there. Now, if in the previous year the provision was not there, then how it can be made applicable in respect of the previous year?
No, just show us the conflict between the division bench judgment and the Supreme Court judgment.
That's why I was submitting. The conflict is here, where the division bench has held that it will be applicable in respect of the previous year, though the provision was not there.
That. Now let us see the Supreme Court judgment.
Supreme Court, you also similar. Now it is well settled that the Income Tax Act as it stands amended on the first day of April of the financial year, must be applied to the assessments of that year.
Correct.
So this act was amended and the provision was incorporated on 1st April 2009. So the financial year starts from 1st April 2009 to 31st.
No, financial year will be 1 year prior to the assessment.
Well, it amendment you'll also see, it's again saying,
Ah.
when it stands amended on the first day of April of any financial year.
Yes.
Well, amendments are not made
As
on
I said, amended on the first day of April of every financial year. Yes.
well, amendments are not made in the assessment year. Amendments are made in the financial year. So if the amendment was made on 1st April 2009, then it will be applicable in respect of the assessment year of that year. So when the amendment was made on 1/4/2009, then it will be applicable in respect of the assessment year for that financial year. So the financial year was 2009-10, and thereby in some similar Supreme Court, as per the Supreme Court judgment, the law which will be applicable will respect of the financial year 2009-10, because the assessment is made in 2010-11 and the rate
this amendment. Let us see 8B now.
My lord. You'll also see the act, my lord. What is it, please? My lord, at page 24.
Yes.
3(8)B, my lord.
8B.
My lord. Notwithstanding anything contained in any of the provisions of this act, in case an SSC being a company which derives income from cultivation, manufacture, and sale of tea, if the agriculture income tax payable under the act on the 60% portion of agriculture income computed as per the provision of Income Tax Act 1971 is less than 10% of the 60% of the book profit computed in the manner as referred to in section 115 JB of the Income Tax Act 1961, 60% of such book profits shall be deemed to be the agriculture income for the purpose of levy of agriculture income tax under the Act of such SSC, and the SSC shall be liable to pay agriculture income tax at the rate of 10% of the agriculture income. Now, this was brought for the first time in the statute book. In the Income Tax Act, the provision was there, 115 JB. But as you'll also be aware, the 60% is assessed as per section rule 9 is bifurcated. So far as the income portion.
No, one thing, frankly, between the three of us, I think I'm the least aware of the provisions of the Income Tax Act.
You'll also be dealing daily.
You'll also be slightly patient with.
You'll also be dealing daily with the income tax and excise matters, what in short, my submissions, which I will also see. You'll also see the rules, Rules kata say. ये कॉपी रखा नहीं जाते कोर्ट पोजीशन हमने नहीं Act you will also see. I bought the copy of that. Act copy the copy. Period how many? Nello simile. Mile, I'm sorry.
Okay, well, Professor Rao, now, according to you, because of the because of the judgment of the Supreme Court in the PSA case, now the amendment came into effect from 1st April 2009, the financial year of 2009-10. And as such, when you then that has to apply, that financial year would have to be construed keeping in view the assessment year income of that financial year can only be assessed in the year next year. So according to you, it should be from 2010-11. The assessment year should be 2010-11.
In respect of the income of 2019.
Correct. Because so that is your contention,
Right.
correct?
Well,
Now, so
right.
as per the Supreme Court judgment, that is according to you in your favor.
Right. Because
I understand.
any amendment which is made in respect of the financial year,
Financial year,
not in respect of the assessment year.
correct.
Now, you lost me kindly single, take the trouble.
Now, but what about the division bench judgment?
Division bench, you lost me single.
Wrong here.
Because it says that it will apply to 2008-9, irrespective of the fact.
Because the assessment year assessment year is of 2019.
The court has taken it that 149/2009 it was there. So assessment year 2009-10 and thereby income of 2008-9. Perhaps in my respect, some similar. The court has not, it was not brought to the notice of the court. The amendments are not made for the assessment year. Amendments are made for the financial year. And the court has taken a
Okay.
I may give an example, not leaving aside the Supreme Court judgment. Hello, leaving, I'm sorry. But if you go by the general Milord, I'm just giving an example, not to speak of the judgments now. Milord, all the income tax for the current assessment year 2026 March, we have already paid. Everything is directed source, it is paid. In the budget, the tax rate is reduced to half. Instead of 33%, it comes to 17%. Whether the for earlier year, whether tax was paid for the rate which was applicable, will all be entitled to the refund as per the new rates. It will have a large consequences because the new rates for the financial year will be applicable for the earlier year. My lord. My lord. My lord. That's why in the last part it is said, my lord, if you also mechanism, my lord, any amendment of the act which come into force after first day of April of the financial year would not apply to the assessment year of that year, even if the assessment is actually made after the amendment came into force. So that's amendment, and this happened will not be the state. They made an amendment effective from 31st March. So after they felt that it will create difficulty. So by ordinance, it was made 1st April 2000 next year. And you'll also just see page 37. Lordship, can you see the rules also, my lord, at page 37? My lord. But previous year, the definition is there. Financial bills. Lordship, see section 2D. Where? 2D. Right. Save as otherwise provided in this section. Previous year for the purpose of this act means financial year immediately preceding the assessment year. Provided that in case of agricultural income derived from a source newly coming into existence in the said financial year, the previous year shall be period beginning with that date on which the source of income newly comes into existence and ending in the same financial year. So if the person has newly income in June, assuming to June 2026 below, then the financial year will be ending on 31st March 2027. Irrespective of the fact that it started in between. So it is 12 months prior to the assessment year. And it will further explain in the second part. Milo.
Yes, page 21.
21 look, of the
Certification.
repetition look. Milo.
This amendment
Milo.
came on 12th January 2000. So the financial year was 2008. Amendment
21 Milo. 23 Milo. 23 Milo.
plus. So the amendment has come into force from 1st April 2009. But this notification came by creating a new source on 12th February 2009, giving effect from 1st April 2009. So this proviso is to be read in that context.
Below the proviso in my number submission.
If I read again,
Milo.
read again.
Milo. Yes, judgment. Is Supreme Court.
Provided that
I got Supreme Court which is full bench. Milo.
2D1,
Milo. 2B1.
2D, just you read again.
Milo, I'm just it. Yeah. Milo. 2D1 Milo.
The that provided in the provided.
Milo.
Yes, for the purpose of this act, financial year, it will be it's in the assessment.
Milo.
Then provided
Milo.
that in the case of agricultural income derived from a source
my lord,
newly coming into existence in the same financial year,
my lord.
the previous year shall be the period
Hmm.
beginning with the date on which the source of income coming newly comes into existence in the same financial year. How do you interpret this?
My lord, from 1st April, a financial year starts, 31st March ends. Now, a person has got a new source of income in July of that year. Now, it will not mean that because it has started the new income in July, and thereby it will have a new financial year, thereby it says that the financial year will be ending on 31st March, irrespective of the fact that the new source of income has arisen after 1st April of the financial year. May I read once again, Mila? Perhaps I will be able to clear. Provided that in case of agriculture income derived from a source newly coming into existence in the said financial year, the previous year shall be the period beginning with the date on which the source of income newly comes into existence, ending in the same financial year.
Now, this has to be read. This is connected with the substantive part. Because that financial year means the same financial year. Means it is related to,
That income.
no, that has to be substantive part. You have to read the end, the substantive portion as well as the provision together. Otherwise, the same financial year, the meaning will not be.
In my what I have understood,
Because provision can be read in three separate.
well, what I have said, a financial year generally should be from 1st April to 31st March.
I'm not on that. So I'm not on that.
No, lordship is a
The
provision.
proviso,
My lord,
you see, let us read
my lord.
from previous year for the purpose of this act means the financial year
My lord,
immediately preceding the assessment,
my lord,
right? Provided that
my
in
lord,
the case of agricultural income
my lord.
derived from a source newly coming into existence in the same financial year. This same financial year is related to that
In the first part,
first part,
my lord.
right? Now,
My
you
lord.
make an interpret.
Now, if you lordship may see first part, it is very clear, save as I have provided in the section, previous year for the purpose of act means financial year immediately preceding the assessment year. So, but I think two will make it clear if you also goes through the two, my lord. Well, perhaps I've not been able to convey. In fact, if your lordship reads 2, my lord, it may make it clear, my lord. 2 your lordship reads it, my lord.
Now let us read once again.
My lord.
2D1.
My lord.
We are putting the year now.
Right.
Year now. Previous year for the purpose of this act, the financial. Immediately preceding the assessment.
Assessment.
Now let us put the assessment year 2009,
10.
10. Then previous year will be
8, 9.
8, 9.
My lord.
And what will be the financial year?
And it should be the same, my lord. 8, 9.
Now with provided that
My
in
lord.
the case of agricultural income
My lord.
derived from a source newly coming into existence
My lord.
in the same financial 2000
8, 9.
because the notification is of your bill.
Look, subject.
Let us
Well, I will just. Well, yeah.
not the final.
Absolutely correct. You're also correct.
So I am just putting it
No, 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 absolutely correct. No.
in the same financing. The previous year shall be the period beginning with the date on which the source of income newly comes into existence. That will be 12 February 2009 and ending in the same financing. 31st March 2000.
Right.
If we put the dates, that is an interpret that would be. I'm saying.
Well, absolutely correct. My lord. I must explain. You. If whatever your lordship is saying is
Because
taken.
you take a position because I am very novice in income tax.
No, my lord, everybody is learning.
So-
Everybody. Lord, if whatever your lordship is saying, if that is to correct, then also the income arising from 12th February 2009 to 31st March 2009 only can be made taxable.
Right.
It cannot be from 2008 to 9.
Entirely.
Entire cannot be there. Now, as you also know, the notification was issued, but unless and until it is made effective, it cannot be a part of the statute. It can become a part of the statute only once it is brought into force. 12th February, the notification was issued, but that was made effective from 1st April.
Notification is in force. No, act is in force.
Act is, act.
Application will start.
So, that is not
That
a
is a
part.
different issue.
That is not a part of the act.
No. How can it be?
It will remain in the state.
Notified.
Well, it will remain in the statute. Government, no effect.
No, the source starts.
The source will not start because this section which has been incorporated in the act, unless it is given effect to, it will remain in the statute only as a government, nothing. A provision cannot be said to be in the statute effectively unless it is brought into the force. D2, my lord. You'll also just see, my lord, the example which has been given. Previous year in relation to the assessment year commencing on the first day of April 2089. You'll also just note it, no? Means the period which begins with the date immediately following the last day of the previous year, relevant to the assessment year, commencing on the first day of April 1988 and 31st March 1918. So it says, my lord, the previous year in relation to the assessment year, so-and-so, 1989, will be 88-89. Assessment year commencing on 1st April 1989. In respect of that, the financial year will be 88-89. And my lord, Jesse Chaudhary will ask me a question in respect of certain further clarification. The reason of the proviso is that, if any person has derived a particular income in the part of the midst of the financial year, then in respect of that income, the previous year will be from the date of accruing that income to the 31st March of that year. If your lordship takes the trouble of once again reading the proviso, I may again read below. Provided that in case of the agriculture income derived from a source newly coming into existence in the said financial year, the previous year shall be the period beginning with the date on which the source of income newly comes into existence and ending with the same financial year. So assuming August, so from 31st, assuming income is arising on 1st August, started from, so it will be 1st August to 31st March. One cannot say, that is for the region, Milord, that one cannot say that no, at the beginning of the previous year, my income was not there. So it will go to the next previous year. To safeguard that part, it has been included that if in the midst of so it starts, then it will be from the date the income starts accruing to the end of the financial year. Otherwise, people will postpone the income Milord to the next previous year. So now we'll also take the trouble of looking at my lord.
Just one the sequel to the query put by Brother Chaudhary is that if it is supposing it accrues on the day when the amendment was made, 12th of February, then ordinarily the previous year would end on 31st of March of that year and would be available for assessment for the next assessment year, and it will be that previous year.
Absolutely.
In this case, you say that is not available because it had been brought into effect from 1st April of 2009. Now, in that context, how do you explain the view of the apex court at para 8?
My
Karim Tharuvi judgment.
My lord. Any amendments in the Act which come into force, Your Lordship, again once noted, which come into force after first day of April of any financial year would not apply. So first of all, the last 3 lines will be only when it comes into force.
Does it mean that Supreme Court has said that all amendments which come after 1st day of April would not be applicable for that assessment year?
My lord, for the assessment year, it will be applicable.
No, that's what it says.
My lord.
Would not apply to the assessment of that year.
My lord.
So it excludes the financial year, previous year. If the amendment comes after 1st day of April,
Like May it comes.
can be on 2nd
also.
3rd April.
Fine.
Right? But if it comes on the 1st day of April, then the income made in the previous year, the amendments will be applicable.
If it comes on the 1st of any financial year, then it will be applicable in respect of income of that financial year.
That's not what
You'll also once again read,
the Supreme Court perhaps says.
You'll also see, now it is well settled that the Income Tax Act as it stands amended on the 1st day of April of any financial year must apply to the assessments of that year. So the assessments of that year. So if it is coming to force from 1st April 2009, then the assessments of that year, it will be applicable.
Now come to
Paragraph 40.
situation is very clear.
My lord.
Come to paragraph 40.
My lord. In fact, there is
That should be good, just right?
the paragraph numbers are not there. My lord. My lord. My lord.
But Structural Act,
My lord.
having come into force on September 1,
My lord.
like this,
Hmm.
1957, and the ceded not being retrospective promotion not be regarded as law in force in the commencement of the year of 1957. Clear, right? Since the Sorcerers Act was not the law in force on April 1, 1957, no sorcerers would be levied under the ceded against the appellant in the assessment year 1957. Now, if you read this, the context of para 8, everything after 1st April will be the next assessment. Now, just paragraph above it.
My lord. The decision.
Decision is the authority for the proposition that the subject of the cert is the income of the previous year. The law to be applied is that enforced in the assessment year unless otherwise stated or implied, right? This, the Constitution bench has approved and acknowledged that decision in CID versus IS 9, which
My
is
lord,
quoted in paragraph 13
my lord,
as the authority,
my lord.
right? Now read paragraph 13. This might be the situation.
This is the lord. This court affirmed the decision.
High Court. The High Court has, however, relied upon a decision of this CID versus
My lord. It is observed that we are here concurred with two lines. 1st April 1940, when the Act came into force, and 1st day of April 1939, which is the date mentioned in the amended proviso. The first question is answered in whether their dates are to apply to the accounting year or the year of assessment. They must apply to the assessment year because the income tax matters the law to be applied to force in the assessment year unless otherwise stated or implied. The first datum line therefore effected only for the assessment year 4041.
Yes.
And because the amendment did not come into force on the first day of April 1940, that means that the old law applied to every assessment up to the year 3940. So, Milord, you'll also see first two lines, Milord. Perhaps
First datum, 1st April 1940.
Act came into force from 1st April 1940. Thereafter, you'll also see when they came into, and the first day of April 1939, which is the date mentioned in the amended proviso.
No, we are not, that I have read that, Judge.
Well, I have also, I think,
It is different. The datum is 1st April to 1940.
1st April 1940, it came into force. Now, the court was examining the question of the second part of the 1939, 1st April 1939. Thereby, the court has said, perhaps, Milord, a plain reading what I am reading, Milord.
Because Constitution bench in the after that has said it is the authority.
Milord,
Subject to
Milord,
with my limited understanding.
no, Milord, Milord, what I was trying to submit before lordship, Milord, that this law has come into force from 1st April 1940, 2009. Although the notification may have been issued, you'll also find in the Companies Act, in the Insolvency Act, many provisions are there which have not been brought into force at all. They cannot be said to be effective. And the Supreme Court says brought into force. So till it is brought into force, my lord, it cannot be effective. Now we'll also just see page 37, how they have understood. Page 37. My lord, of the petition.
Litigation.
My lord. Lord, these are the rules framed to give effect to Section 8B of the Assam Agriculture Income Tax Act. Now, this was framed, notified on July 2010. Now, various requirements have been mentioned, including the return form. You'll also find page 38. Now, if the income of 2008-9 also 8B applies, then the returns, all other requirements have to be fulfilled in 2009 itself.
This is about the mechanism.
No. We'll also see it has far-reaching consequences.
Yes, because HC has been brought. HC.
My lord. Now,
To do the
procedure. Now, if the chartered accountant report is to be submitted on the basis, there is a penalty. And how they have understood, not here, from past also, you also may see, I've given the petition.
let us read 8B. Whether it is impossible.
My lord.
Page 20.
Page 24, my lord.
Let us read 8B.
My Notwithstanding in the content in the other provisions of the Act, in case an assessing being a company which derives income from cultivation, manufacture, and sale of tea, the agriculture income tax payable under this Act on 60% of the portion of the agriculture income, as per the Provisional Income Tax Act, is less than 10% of the 60% of the book profit, computed in the manner as referred to section 115 of the Income Tax 1961. 60% of such profit shall be deemed to be the agriculture income for the purpose of levy of agriculture income under this Act, and SSC and the SSC shall be liable to pay agriculture income at the rate of 10% of sales.
This looks like a readjustment and recalculation.
Not calculation. A fresh,
Indeed,
my lord, a fresh liability has been created.
liability hasn't created, but this liability can be calculated
Yes,
by the already
existing provisions.
existing
As per the Income Tax Act, the provision,
some period.
my lord, but
If say, if it goes beyond 60%, like that, something, it will recalculate.
but my submission follows that in the taxing statute, first charge, then manner of computation, assessment, then recovery. And as you also be aware, the judgments of Supreme Court that if any vagueness in any of the three are there, then the charge goes. If the liability is there on me, and the manner and the submission of returns, etc., is not prescribed at all.
Yeah, that is, I think, not the subject matter of reference perhaps.
No. The reference question will come on the basis of this only. So these are the, my lord, on the basis of these submissions, I am saying that it is effective.
That will be in the repetition.
In the, no, the question is that 2019, nothing will survive if once your lawsuit says it will be applicable for 8-9, then the repetition goes. And if your lawsuit says that 2009-10, the repetition allowed. So there is no further question to decide in the repetition. The reference, whatever your lawsuit decides, on the basis of that, the repetition, the fate of repetition also depends. Now your lawsuit may kindly see, in the past also, number of amendments were made by the department. And they were all given effect to in the next assessment year. The tax was reduced. That was given effect to from the next assessment year. I've given all examples of this one. Now, you'll also kindly note it, my lord, that any amendment which is made in the Act is not with the assessment year. It is with the previous year law, which is on the first day of April of the financial year. Well, in my humble submission, it will have a far-reaching consequences. If it is said that 1st April 2000 of any law which is there, it will apply to the last year. Both sides, it will have a far-reaching consequences. The SSA may have to bear a burden of the increased rate of tax. The revenue may have to return the amount which it has already collected on the basis of the existing law. It is never, in my humble submission, the intention or the law that the law has to be applied in every case retrospectively. Otherwise, every law will be retrospective in effect. Well, I have to pay the advance tax on the basis of income I have earned. I have to pay advance income tax on the basis of the rate which is applicable. Next year, the rate goes by 10% more. My advance tax will be soared, interest will be leviable, penalty will be leviable, everything will be leviable because I paid less advance tax on the basis of law which was applicable. So, my lord, the law cannot be the law which is applicable by way of an amendment. Once the amendment is 1/4/2009, in my humble submission, the law that will be applicable in respect of the financial year 2009-10, relevant to the assessment year 10-11. In fact, that is my all humble submissions. And the department has also in the past, I've given examples in the petition. They have understood in the same way, applied it for the next assessment year. That has been done in that way only. If my lender friend, after reply, my lord, if anything submission further is there. Well, there are 2-3 judgments are there, but on the same line, that's why I am not burning if you ask. Again, please. Well, the Supreme Court judgments, Constitutional Bench judgment. Well, that judgment in my humble submission, 4 lines. If you also reach the first part and second part, the second part, my lord, is with respect to different aspect, and first part different aspect.
8 and 14 of the Supreme Court judgment, it doesn't seem to be very clear.
Well, earlier the Supreme Court judgments were only 4-5 pages.
Uh,
That's why in after 20, 40 years, 50 years also, we are again saying the same things. Nowadays 1000 pages, the same thing is again repeated. So,
okay, one thing out here in para 8, here, as para 8, your argument, the submission seems correct. That it stands amended on the first day of April of any financial year, must apply to the assessments of that year. So the assessments of that year will be assessed and decided on the next year. And any amendments in the act which come into force after the first day of April of a financial year, after the first, would not apply to the assessment for that year, even if the assessment is actually made after the amendments come into force. Now you come to para 14.
my lord,
The Surcharge Act having come into force on September 1, 1957, and the said act not being retrospective in operation, it could not be regarded as law in force at the commencement of the year of assessment 1957-58.
my lord.
You see, when we juxtapose this portion with para 8, out here also, even if the September 1 was considered to be April 1st, then the year of assessment will be the next year, supposed to be the next year.
If you also just, I may read again, if you also permits me. The Surcharge Act having come into force on September 157, and the said act being not retrospective in operation, could not be regarded as a law in force at the commencement of the year of assessment for 1957-58.
Correct.
So for assessment year 57-58, the court says that it is not retrospective in operation. Therefore, it will not apply in respect of the assessment.
Now, so that means it will apply to 58, 59.
You know, it says assessment year 57-58, it will not be applied.
Okay.
Now, in my case, what
So the assessment year will be which year? 58, 59.
58-59.
So what is the difference between 8 and 14?
No, 8.
8 talks about when the amendment comes into effect on 1st April. But and thereby the assessment year, according to you, will be the next year of 2010-11. And then now when you come to para 14, it says that if it is 1st September, then also it will be 50.
I'll also read the last 3 lines again.
Ah.
Since the Surcharge Act was not the law in force on 1st April 1957, no surcharge could be levied under the Act against the appellant in the assessment year 1957-58.
Correct.
My lord.
Now, come to paragraph 8.
My lord.
Second line, that's a
My lord.
any amendments in that which come into force after first day of April of a financial, that is September, in paragraph, would not apply to the assessment of that year, even if the assessment is actually due after the amendment starts. So that paragraph, second part of this paragraph 8 fits into paragraph 40. Now,
My lord,
your submission from yours perspective. If we read paragraph 8, now it is well settled that the income tax, as it stands, amended on the first day of April 2009. According to you, the previous year will be 2019.
8-9.
Right?
Nine.
No, not previous, yes, that's
First
right.
April
Right,
2009.
previous year.
8-9, my lord.
No,
Then-
My lord, my lord, my lord.
There is nothing.
My lord, my lord, I fully appreciate it. I was swayed away by the division bench judgment.
Right. So, first of April 2009. Then the previous year will be
9-10.
2019. And the assessment year will be
10-11.
2010-11. And if we go by that, the next second part will be that anything after 1st of April, the assessment year will be, previous year will be 2010-11. And assessment year will be 2011. If we accept your submission.
Not my submission by the Supreme Court said, not my submission. If you also read once again the last 3 lines, my lord. Take the table, I will slowly read. Any amendment in the Act which come into force after first day of April of a financial year would not apply to the assessment of that year, even if the assessment actually made after the amendment has come to force. So for that financial year, 9-10, assuming the amendment would come on 2nd April 2009, then it would have not applied for 10-11 also. Because the Supreme Court said, if an amendment is made after 1st April, it will not apply to the assessment year of that year. It would have gone to 11-12.
Since it was made effective from 1st of April, it will apply to the assessments of that year, meaning previous year,
10-11.
previous year.
10-11 for the assessment year 10-11 for previous year 9-10. You'll also read once again the
So, your submission is basically this. The amendment came into force on 1st April 2009. That is in the financial year 2009-10. And accordingly, in terms of para 8, the first part, the assessment year will be 2011.
10-11. So that is my
That
submission.
is it.
And
If we read the second part of para A, the assessment year will now jump to
11-12.
11-12 because the amendment, any amendment that comes after April, 1st April, would ensure that the financial year becomes the year the next year, the later.
With due respect,
Now, when you read that, correlate that with para 14, there seems to be some dichotomy.
my lord,
Para 14 does not say that.
it is very difficult for me to make any comment.
No, we are just giving.
Absolutely correct. Absolutely correct, Your Lordship. If it is correct, but the Supreme Court said it is well settled law in the 8th. So that is well settled law, my lord. If the Supreme Court writes anything, my lord, what can be done?
What we are trying to find out is whether there is any, any difference of opinion in the division bench judgment and the Supreme Court, or is there anything to decide?
My lord, my submission for the division bench judgment is that the division bench has said that irrespective of the fact that the provision was not there in the previous year, the tax will be leviable for that previous year, which is not the law as per the Supreme Court.
And since the rules were also not broken.
In 2010, and earlier notifications, which whatever they have made amendments, they have made it effective from the next assessment year only, financial year for that year only. So it is not so that they are not aware of it. they are also aware of the same law that it will be applicable for next year. Otherwise, without the rates were reduced, everything was reduced. I would have got for the earlier years also refund. So, my lord, in fact,
We'll have to, even supposing, another question. Supposing there was a difference of opinion between a division bench judgments and the Supreme Court. What is there to decide? Follow the Supreme Court judgment.
yes, sir. That's the per incurium. I brought the judgment that if any judgment is there, possibly well aware I did not place it. If any judgment is there that was not placed before the court, perhaps if the judgment would have been placed before the court would not have taken this view.
But we will have to see whether the Supreme Court judgment and the division judgments are at odds with each other. Or
If the law, whatever Supreme Court let down, the division bench let down the same law, nothing is there. I have nothing for making submissions.
say the other side.
My lord, my.
My lord, will kindly have a look at the section 3 of the, my lord, Agriculture Income Tax Act. Perhaps, my lord, that was the provision which was considered by the division bench, my lord.
Section 3 of the
Assam Agriculture Income Tax Act, which is the surging section, man.
yes.
Says charge of agricultural income tax. Agricultural income tax at the rate or rates specified in the schedule.
Just a
Sub-
minute, just a minute. Page,
My lord, just one minute. Chapter 2, my lord.
page,
Oh, my lord,
that's different.
no. It's 3.
Ah.
It says agricultural income tax at the rate or rates specified in the schedule, subject to the provisions of section 6. Lordship will mark this, shall be charged for each assessment year in accordance with and subject to provisions of this act on the total agricultural income of the previous year of every person. Since the charging section says, my lord, that tax will have to be charged in the assessment year. And the amendment came in, my lord, 1st of April 2009, my lord, which in that case, my lord, the assessment year will be, my lord, 9 and 10. And the agricultural income, which is to be assessed, will be of the previous year. That is why, my lord, division bench held that, my lord, since the provision says that it will be imposed in, my lord, it will be made applicable in the assessment year. Lordship will mark this much charge for this assessment year in accordance with and subject to the provisions of this act on the total agricultural income of the previous year of every person. And if you also sees the judgment of the division bench,
Yes.
para 5 and, my lord, para 8. We are unable to accept this submission. Or Lordship will say para 4 also, my lord. What was the submission made before the division bench? According to the petitioner, since the amendment act so and so came into force on 1/4/2009, it could not be intended to tax income of the previous year, that is 8 and 9, nor it could be intended that advance tax was payable in respect of such income. Similarly, revised rate of tax by so and so could not apply to previous year when the act was not in force. We are unable to accept this submission. Under the scheme of the act, the tax is payable for the agricultural income of the previous year. The assessment is very important. The assessment is made in the next year. That is in the assessment year at the applicable rate of tax. Admittedly, the amendment provisions are applicable for the assessment year in question, and the same could be applied to the previous year irrespective of the fact that in the previous years the said provision was not there. And in the next page, my lord, Honorable Division Bench has referred to, my lord, section 3.
But where the provision is incorporated in the assessment year,
Lordship.
income has to be relatable from the day when the amendments are made. Right? Let us take a very hypothetical.
In that, yes,
Let us take a very hypothetical example.
Lordship.
The Income Tax Act was not there.
Lordship.
It has come into effect, or it will come into effect from 1st of April 2026.
My lord.
Can it be said that income made in this year, 25-26 up to 31st March, would be taxable in view of the fact that the Income Tax Act has now come in the year 2026? And therefore, when you say assessments of that year would include the previous,
Lordship.
or will it mean assessments of that year would be the assessments pertaining to 26-27 relating to, 27-28 relating to previous year of 26-27. When the law is not there, the law has been given effect from a particular date. Your income
My lord.
vis-a-vis the law will have to be decided from the day when the law is there.
My lord.
Now, under the scheme of income tax or agricultural income tax, income which you earn is taxable only in the next year. Income which you earn in a financial year
My lord.
is taxable in the
Yes.
next year.
Go by that time, my lord, financial year and my lord, assessment year.
Financial year and previous year.
But my lord, the para 13 of the judgment, my lord, which has been already, my lord, placed.
Of the division bench.
No, of the, my lord, on Supreme Court. The T state, my lord, para 13. There, my lord, it has been referred to the IT Commissioner versus IS lines. There, my lord, again, it says, my lord, in between, they must be held to apply to the assessment year, because in income tax matters, the law to be applied is the law in force in the assessment year unless otherwise stated.
Correct.
Then, my lord,
Now-
down below.
Now, can it be understood to say or mean that the law to be applied for the assessment year will mean the assessments for that year, which in effect you are making in the next year. Assessments for this year.
May I, my lord, regarding, say, my lord, taking the sale tax and all, my lord. There, my lord, the burden is shifted upon the buyer by the seller. Say, my lord, 10% tax is there. For, say, last year, my lord, it was 10%. This year, suddenly it has been made 12%. Now, if we say that it will may be applicable for the last financial year, then, my lord, the seller will be in problem because he has searched. But in the income, my lord, in case of income tax, whether, say, supposedly 30%,
That's what I'm saying.
if that cannot be done, my lord, we will.
Hypothetically, you take a case that the Income Tax Act was not there. It is now coming in the year 1st of April 2026.
My lord.
Income which you earn, which you are earning now, till 31st of March, will it be taxed with effect from 1st of April? Or it is the income which you earn with effect from 1st of April to 31st of March 27, which will be available for assessments and taxation in the year starting from 27-28.
And that is what, my lord, the other side is trying to, my lord.
No, this is
pursue before the honorable court.
with reference to the definition given under the Income Tax Act, agricultural income tax,
Yes.
what is a financial year, what is an assessment year. So there is no dispute or
Yes,
complete
on definition, but no dispute.
assessment year will relate to the income earned in the previous year.
My lord.
Now, for the income to be assessed in the assessment year, there must be a set of laws in the previous year applicable.
No, my lord, again, my lord, coming to this, my lord, judgment in the last line that has
Right.
been placed by this honorable.
Available for the assessment of that
It
year.
says, my lord, since the Surcharge Act was not the law in force on 1st of April,
Right.
no surcharge could be levied under the said act against the appellant in the assessment year. Also will mark this, my lord, assessment year 1957-58. Now, if it was on, my lord, 1st of April 1957, it could have been possible. That's what we take out, my lord, from this particular.
That's what we are all trying to find out the correlation between para 8 and
8 and para 4. Yes, my lord. Para 4.
going by the definitions available.
And, my lord, para 8, my lord, in my humble submission, my lord, if I read the first line, which according to the, my lord, petitioners herein is in their favor. It says, it is well settled that the income tax, as it stands amended on the first day of April of any financial year, must apply to the assessment of that year means I would say it is the assessment year, my lord.
Exactly.
That is that particular year, my lord.
Assessment, that is one way to argue. But can it also be said that the assessments of that year would be
Means
income which we have earned in that year
the 9 the financial year assessment.
subsequently? So the assessments of that year must be in relation to previous year and assessment year, the manner in which you make the assessments, namely in the succeeding year, or the income earned in the previous year. Subject to correction by Dr. Saran.
My lord, one judgment more, Kerala High Court. I'm a place, the judgments of Supreme Court have been only considered and the same law has been left out. In fact, this judgment of a lordship, although it's for an assessment year, but will have a far-reaching effect on the income tax assessments also. So, my lord, the interesting point which is come up for consideration. It is para 6, 8, and 6 and 8.
Okay, then.
It may go benefit also.
Actually, we are not doing any agricultural.
No, my lord, the income tax rates may reduce next year. It will, you also get the refund of the earlier year.
If we put it backward, then we'll get the refund.
My lord, it is not going to be increased in future. It is going to be reduced. So naturally, you are also going to get the refund, and I will be the consignable.
6, 8, then.
6 and 8. And agriculture income tax act is still there. It is still, it has not been repealed, my lord, with the GST. So, my lord, the state will have to be very cautious because now they are making submissions. So by making any announcement in the budget, all will be retrospective.
Any other? This is one.
My lord,
This is one judgment.
my lord. And on per inquiry, my lord, I given judgment to your lordship, my lord. The Supreme Court, para 19 to para 21. It starts, my lord, with, in fact, discussion on per inquiry from para 17. Para 17 to 21. Although your lordship is well versed, but just it came to my notice sooner than. And I always say when we appear before Justice Chaudhary, my lord, we have to read every line of the annexures and the judgments, and we cannot come. Because my lord also reads every line. goes through it. So we have to be
Every word of.
every word. So we have to be, also very careful and read every line. And we have learned, I've learned a lot when I argued one case in the tax matter before my Lord Justice Chaudhary. So many issues came up and so many issues were decided. So we also learned in that way, from the lordship also, when I appeared in the tender matter.
No,
I
I have
learned a lot.
not. That.
No,
I was right or wrong, I don't know.
we have all learned from
Mr.
you.
Gogoi will.
Not the other.
No, my lord, that judgment has become very important judgment, and it is All India Journal also all reported. So many issues have been decided. Justice Saikia is now in tax matters, judgments are regularly being reported. I am highly obliged, my lord, for giving me present hearing. Additional.
Assisted by Mr.
A costing.
A. Kochi.
A costing.
A. Double A.
No, sir.
Only a.
Mr. B. Gopal, and then additionally, well, all this thing. And Mr. Assisted by.
M we are, my lord.
Get it concluded? There's been reading.
I'm highly obliged for giving a present hearing.
Yes. Yes,
With your lordship counsel, madam, with regard to item number 12, madam,
yes.
the DNA report was called for, it has been received, madam, it is in favor of the appellant, madam. May that matter may be fixed in next week, madam, Monday or Tuesday, madam.
DNA report, okay.
It was directed by this court to conduct a profiling, madam. That report has been received.
Okay.
Monday, madam, on 23rd.
Monday?
23rd. Can I pray to be listed at 2 p.m., madam?
No, if you come, but you mentioned that day.
I'm much obliged.
May I please tell us, with the consent of the other side, I beg to mention item 10 for the legal aid counsel.
Yes, for about,
Lordship, I appear for the appellants. I'm praying for a date, Lordship, in the next week.
on the prayer for adjournment made by the council for the response number 2. It is not objected by the appellant's council, is the matter after?
Next week,
Lordship, any date may be fixed. It's ready for hearing.
You take.
Yes, obliged.
May please, your lordship. My lord, conviction under 20B2C.
I don't think it's possible, Mr. Mitra.
yes, madam. It will take some time, madam.
No, not only that. I've got a single bench at
2 months.
2. At 2.
Can my lords have it on 10th of March, if not inconvenient to my lords?
Oh,
We can fight that.
madam, before that, can it be a challenge? I will not be. 16 or 16. Can it be on 16 month? 16.
Okay.
16. March.
16th March.
1/6 month.
I've got a severe cold also. On the prayer, the parties list the matter on 16th.
My lord, is the first item.
As the first item in the hearing.
Bless my lord.
The last question, what did you say? No, the main. No, just like, just be doing it. Promise be doing it. As the matter pertains to
There is a recovery of clothes. Whether clothes, recovery of cloth and some weapon by itself is a incriminating circumstances if that issue Lordship will decide. And this is the main issue Lordship in this case. And other 2, 3 incriminating circumstances is there, but that is not believable. Only this is the main issue.
Lordship, today our office has not provided us with the paper book money.
Page 6 of my
So when do we fix?
a short.
Any date convent your lordship, it will know the Xerox coding.
Uh, when do you want?
Lordship, any date convent.
Right, so on the prayer page for adjournment by Mr. EPS, who submits that he has got the paper book, list the matter of, give a date, when do you want? Give a date.
Lordship, 5th March.
No, not that week. That week we'll be.
Tuesday, next Tuesday, Lordship.
We'll be probably holding DB1.
Next Tuesday, Lordship.
Lordship,
Huh?
All right.
24 to. Yes. This is.
No. 26 of October. 27 is Friday. Can it be minor? Sa episode mo diktar আছে. Ta episode একটু লব নেকি? 9th of March. Lordship. Yes, so DB1 lobo.
6 total there.
26, I have got some rituals. First half, I'll be here. Second half, I may not be in the court. Bosses. 25th.
All right.
Officer Xerox করে মনে আসলে একটু এলাম জন্য নাম্বার পিস পার লিখি দেয় 11. 11, she is there.
Huh?
She's there for me.
Yes, what, madam, what?
So, Your Lordship, my senior land counsel is on his way. I kindly pass over for a time being.
My chairman, don't put. Total single benches. Actually, I have a date.
When do you want? Give a date.
Contact my senior.
Better phone number. It's a
I list the matter on fifth. Madam, you have which item?
I am for item 1 and 2.
Huh?
Yes, it's protected with number 1 and number 2. Item number 1.
Yes, so who's for the government? Your name is?
My name is Nita Bhattacharjee. I'm for the appellant.
I just said doesn't seem to be here. Who?
Sir,
Yes, who is there appearing for the state? Anyone appearing for the state? No, dude, that's not for the state. What to do? What is your case here?
it's on 37, which is with regard to the arbitrator's award, which was passed. The arbitrator rejected few claims
based on the fact that oral evidence was not adduced. When 100% of the documents whose execution and
Can we
existence
go
were
into loan
admitted.
issues?
Yes, Your Lordship, because my documents were not,
Under
No,
what,
that
under which of the headings will it come under?
it will come under patent illegality itself because my documents were not at all assessed. They were not at all evaluated in the first place. So I understand that the 37 court is the appellate court, which cannot reappreciate evidence. So I'm not asking this honorable court to reappreciate the evidence. But my contention is my documents in the very first place were not looked into.
Huh? That will be like re-hearing the entire thing.
No, Your Lordship, my contention is very, very limited. I am not going into the facts or the merits of the award. I am strictly based my arguments on the fact that 100% of my documents whose existence and execution were admitted by the respondents were rejected for the sole reason that oral evidence was not provided, which of course is upheld by the district court in 34, which was filed.
What did the district court say? Let us see whether.
Yes, Your Lordship.
Where is my copy?
So, Your Lordship, for the convenience, I am referring to arbitration appeal number 3 in the arbitration proceeding number 4 of 2020.
The arbitration 3, appeal, criminal
Yes, arbitration
Appeal
appeal.
three.
Yes, in arbitration proceeding number 4. Yes.
page,
Yes, Your Lordship. It's 2F, Your Lordship.
page 2F.
Yes, for the impugned judgment which has been passed by the district court.
Yes.
So in para number 13.18, the district court has laid down its reasons, which of course is legally flawed. So it has stated, I would read the relevant portion. It is stated that it is an admitted position of both the parties that as per clause
13.8 doesn't sound like.
yes, Your Lordship, it's page 32 of 35.
What I asked you. Page 32.
Page 32 of 35 of the impugned judgment, Your Lordship.
What is this?
That's an arbitration proceeding number 4, Your Lordship. Yes.
Where is this page?
If Your Lordship
I have
permit,
no
I
any
would
page.
just assist. Yes, Your Lordship. 13.18, that's page 51. Yes.
So you'll have to paginate your petition with my petition.
Yes, Your Lordship, it's the original document, so it's probably a bit mixed.
Yeah.
Yes, Your Lordship, page that is 13.18.
Yeah.
the district court has held that it is admitted position of both the parties that as per clause 6.1 of the contract agreement dated 26/8/2013, all communication should be in writing. When these communications were placed before the learned tribunal, the respondent never admitted that works worth 12 CR were executed by the claimant for the payment for them. At para 37 of the impugned arbitral award, it has been highlighted that a document whose existence, execution, and contents are in dispute has to be proved by adducing evidence relating to its existence, execution, and contents. The affidavit on admission and denial of the documents filed by the respective parties in the arbitration proceeding being evidence. Such documents whose existence, execution, and contents are not denied and admitted in the affidavit filed by the other party can be the basis for passing an award by the arbitral tribunal. Since no oral evidence in respect of such document need be adduced on the principle that facts need not be proved, at para 27 of the impugned arbitral award, which deals with affidavits on admission and denial of documents filed by the parties, it has been mentioned that the affidavits on admission and denial filed by the respective parties assumed more importance, as the claimant did not adduce any oral evidence despite opportunity. As the existence and contents of the document were in question and not admitted by the respondent, this court fails to find perversity in the decision of the learned tribunal warranting quashing of the same. So that has been held by the district court, Your Lordship.
So it says that were in question.
The statement of admission and denial, all the 100% of the documents were admitted. Its execution and existence were admitted. It is
Maybe the document is admitted, the content might not be.
the content might be disputed, but you can't, they just dispute. They said contents denied. They have not provided any reasons for denial of the contents. Plain, simple denial.
But neither did you prove the document by
My documents speak for itself. I could have proved from the documents itself that the work has been completed. Out of 15 documents, all the 13 documents whose existence and execution were admitted were thrown out solely for the reason that oral evidence
Anyway,
was
let's
not.
see, there's no one here. There's no one for the government. Oh,
We have made.
yes.
There has been some connectivity problem. I would like to tender my sincere apologies.
Yes. So, you're for the state.
Yes, Your Lordship.
So what is your contention? What is your stand?
Your Lordship,
You have muted yourself.
am I audible, Your Lordship?
Yes, yes, yes.
Sorry. Your Lordship, I am a little bit handicapped as of today because I have placed my file in the office. So if possible, if Your Lordship, can I make a reply on some other date?
No, we'll hear you on some other day. No point keeping it part of it.
Mm. Okay.
When can we do it?
Any day, next Monday?
No. And will you tell me? You're from here?
Yes, I'm.
I don't know. You give me a date. No, not that. In March.
10th March. Okay.
On the prayer of the council for the respondents is the matter of saying.
Deeply obliged.
Never mind.
Deeply obliged to Lordship.
Yes, item 3.
My lords, I'm appearing on behalf of the appellant.
Yes.
My lords, there has been one update in the present matter.
Yes.
Along with our appeal under section 34 before additional district and session judge Kolesiv, there was another appeal filed by the respondent herein the present appeal. My lord, their case was registered by the arbitration petition number 12 of 2024. And recently on 3rd February 2026, the order and judgment has come out. So, my lord, this order and judgment says that the matter be remanded back to the learned arbitrator afresh.
How can they be two, the two appeals should have been taken up together?
I'm also surprised, my lord, to know that.
What is going on?
And the respondents and petitioner are both same in both the matters. And it arose out of the same arbitral award.
Now what is to be done?
My lord, our prayers are,
Your appeal was dismissed.
my appeal was dismissed. There was
Their appeal was allowed and
allowed,
remanded.
correct, my lord, afresh.
Then it serves their purpose.
My lord, my prayers are met. So my lord may be gracious to dismiss the matter and may also record that our matter may also be heard afresh before the learned arbitrator. Do you know? Our rights and contention should
No,
remain.
but why should I pass any order? You'll have to now. The decision made in the arbitration petition 12 of 24 will
Mhm.
now hold the field. Will take care of your case also.
Yes, my lord may record the same and may dismiss the present appeal.
Why don't you withdraw this case instead of me passing an order? You can say that because of this order, I want to withdraw it. Otherwise, it becomes a very frequent situation for this court. What is going on? Can we see that order that has been passed in this arbitration petition 12 of 24?
My lord, I have the hard copy with me.
Can you make arbitration petition 12 24? Issue passed by whom? Passed by which court?
Additional District and Session Judge Kolasib.
Can we get it online? Very, very funny thing. Now, what to do in this type of matters? I haven't even had time to think. Yes, what to do, madam, in this kind of cases?
As my lord may suggest, my lord, my humble request is only to take this order on record and may dismiss the matter, saying the matter may be heard afresh, relying upon this judgment before the learned arbitrator.
So, basically, both of you all were going against the arbitrator's award.
Correct. In different appeal, my lord, yes.
This is not done. Who is this? Correct. Heard, Mr.
Karthik Jain.
Your name, Karthik Jain, learned counsel for the appellant,
Yes, my lord.
NHIDC. The appellant has put to challenge the judgment and order dated 2/9/25 passed by the Court of the Additional District and Session Judge Kolasib, by which the appellant's appeal under Section 34 of the Arbitration and Conciliation Act 1996 against the award passed in arbitration petition number 11 of 2024 has been dismissed. Correct?
Yes, my lord.
Mr. Karthik Jain, is that correct? The fact?
Yes, my lord. Just a minute, my lord. My lord, the arbitral award was dated 23 September 20.
Award dated 23
September 2024.
9/24, huh? Passed in arbitration petition number 11 of 2024, correct? You don't even know the fact.
Before additional, my lord, the The date which I have mentioned you
Just
refer
a-
to the
just a-
arbitral award passed by the
Correct,
learned
correct,
arbitrator.
correct. I know, I know. I'm talking about the arbitration petition before the arbitrator. What is the number?
My lord, the number is NH dash
Please show
30.
me the arbitration. Where is the award? Where is the award? Which page?
My lord, page number 53.
Arbitral award dated 23/9/24. Passed in arbitration case number NH 306 /KLB /5 ARB 2020.
Yes, my lord.
Actually, that arbitral petition number 11 of 2024 is the order, is the petition before the first separate court. Okay. Anyway, so just read it. I'll just give you.
My lord, arbitration petition number
Has
11 is
put
the,
to challenge the judgment order date 2/9/25 passed in arbitration petition number 11 of 2023 by the court of the additional district and section judge Kolasi. By which the appellants appeal under section 34 of the Arbitration and Conciliation Act 1960 against the arbitral award number so and so, passed in so and so, was dismissed. Now, how do we have got to know that order?
my lord, the present order in arbitration petition number 12 of 2024 has been passed to us by our clients very recently. This order has been passed very recently on 3rd February 2026 only by the
Were you
additional
part of
district.
it? Were you a part of the proceedings?
Hello, I am assisting Mr. Karthik here. If I may be permitted to assist my lords for a moment. My lords,
Yeah.
I was a party. I was respondent number 2 in this order. Your lordship will see at page number 2. I am a party to this.
Unfortunately, you have not provided us the order. So how can we know where you are? You're for the NHIDCL, correct?
Yes, my lords. Karthik, can you just hand over a copy to his lordships?
Lordship is not in the courtroom today.
Oh,
Lordship is appearing virtually.
my apologies, my lords. My lords, what we propose is we can file an application and move this up, provide the order copy to your lordships, have it tomorrow or day after, we'll have it disposed of. In that circumstances, my lords.
No, but tell me, how did this happen to pass?
My lords, these are cross appeals. It's an
These,
ordinary.
these are cross appeals, they should be decided together.
Yes, my lords, that's ordinarily what the course of action the learned trial court ought to have taken. However, unfortunately, my lords, in this case, that has not happened. So my order came first, and then came the cross appeal order, my lords.
Then why didn't you mention, have you mentioned anything about the cross appeal in your appeal before this court?
We have not, my lords.
Then?
Apologies to that extent.
Why are you playing hide and seek with the court?
No, my lords, that was not the intention. In fact, the information actually came to us also a little later. Had we known, of course, that fact would have been disclosed.
Mr. Counsel, this order passed
Hmm.
in 12 of 24
Yes, my lord.
was on February 3rd. And this matter had been pending before the court in the year 2024. This should have been part of your pleading. This should also have been part of, this should have been brought to the notice of the court much earlier, and you should have also brought it to the notice of the district court that he could not have passed such an order without disposing of the constitution also. You are playing around with the court, this court.
My lords, my difficulty is that insofar as a 37 petition is concerned, I am only limited to a 34 order. So
No, that is all right. You are limited to 34 order, but you kept silent about the appeal filed by the respondent.
Well, it's to that extent I can
Why don't you have to pay?
agree.
I think you should pay cost, heavy cost. You cannot play around.
Well, that was not the intention. It's an inadvertent error, and that's on the part of the councils.
No,
Be
no, I think we'll have to pay cost. Some cost.
Mullahs will please, Mullahs will just.
How much will you pay?
I can only beseech Mullahs to be kind to us.
It's not done. I'm taken by surprise. Not only by your conduct, of course, but by the court itself, by the lower court, the district court. How did it come to pass?
But in all fairness, as an officer of the court, I can mention this part that had we in fact known this preposition, we would have done that.
On the preposition, the appeal was filed. You took part in the proceedings of arbitration petition 12 of 24.
Yes, my lords. I can see a counsel representing respondent number 2, my lords, in the.
Then
My lords, be that as it may,
we'll take it up.
The limited submission that we were endeavoring to make was this, that this appeal can be actually disposed of in
I
view
know, but we'll dispose it of. But then we'll also impose some cost. It's not done.
Mullahs, we tender an apology. Mullahs will please waive off the.
No, there is nothing mentioned here with regard to filing that you were a part of another appeal. All right. The appellant's counsel submit that while the appellant's appeal had been dismissed, appellant's appeal under section 34 had been dismissed. The appeal filed by the respondent number 1.
Mullahs, these are all the respondents.
All the respondents.
All 8 respondents.
By all the respondents. While arbitration petition. What is the appeal number?
12 of 2024.
While arbitration appeal number 12 of 24. Arbitration petition or arbitration appeal?
Mullahs, it's arbitration petition.
While arbitration petition number 12 of 2024 was disposed of on 3/2/26 by the additional district taxation judge policy by setting aside the award, arbitral award, by setting aside the same arbitral award and remanding the case back to the learned arbitrator. Or is it a council? How many members are there in the is it a arbitration council or arbitrator?
Well, it's sole arbitrator.
To the arbitrator, the sole arbitrator, for taking a decision, for taking a de novo proceedings. Is it? What is the word used?
Well, the matter is remanded back and directed to reconsider the matter afresh. The word used is afresh.
And remanded the matter for reconsideration of the matter afresh. Next, the learned counsel for the appellant thus claims that he may be allowed to withdraw the present appeal. Next time. This court is surprised to learn that the same Court of Additional District Assessment Judge policy would have passed two different orders arising out of two different appeals. No, not arising out of, in respect of two different appeals arising out of the same arbitral award. This court is even more surprised to learn that the appellants here have not made a mention of the pendency of arbitration petition 12 of 2020, which had been disposed of on 3/2/26. That is after disposal of the arbitration petition number 11 of 2022 by judgment and order dated 2/9/2022. The appellant had the duty to be fair to the court and would not have played hide and seek with facts. With the court, with this court. As the order dated 3/2/26 disposing of arbitration petition number 12 of 2024 has not been produced before this court today. List the matter tomorrow. Tomorrow at 3:30. At 2 o'clock. At 2 o'clock. We take it up at 2. In the meantime, the appellant's counsel shall transmit a copy of the order dated 3/2/26 passed in arbitration petition 12 of 2022 to this court. I do not know how you do it somehow. How you can send it by mail to whom?
Manoj, we'll take the email ID of the court registrar, Manoj, and then calculate it.
You take the court master. What is your number?
Manoj, I'll just type it down in the chat box.
It's code 2.gsc.
Code 2.
.ghc.
2 is in numerical, sir.
Yes, yes.
GHC.
.ghc. GHC small.
J as in
G,
Jaipur.
Gauhati High Court. GHC.
Right.
At gmail.com.
At gmail.com.
You send it by today.
Yes, please, Manoj.
It's a very funny situation.
My lord, tomorrow is a state day in Mizoram, so should we list the matter tomorrow or some another day?
You don't have to be in court.
Yeah, my lords, that's what I was asking. It's all right, my lords.
Gauhati we are working.
Yeah, my lords, no problem.